of this bill and look forward for the discussion to come. So Bob, why don't you begin by walking us through it, and we'll ask questions as they arise, section by section.
Okay, good morning. This is actually a second time around for this bill. It was introduced in the last council, before the last council, and actually I don't think it ever got past the work session. I'm not sure it even got to a work session, I believe. But it's a bill that's a little outside of the ordinary for the council. It would require, it affects private sector employees, it could affect county employees, but really doesn't. It affects a certain group of employees that do provide building maintenance services in large office buildings in the county. It has the types of employees we're talking about are, let me say, there's a list in the bill itself I should look at. An individual employed at a covered location as a janitor, building cleaner, security officer, concierge, door person, handy person, or building superintendent. It excludes a managerial or confidential employee, an employee who works in an executive, administrative, or professional capacity, an employee who earns more than twice the wage requirement required under our wage requirements law, which actually doesn't apply to these employees unless they're on a county contract. Essentially, these are people who are making less than twice the living wage that we require for our contractors' employees. It also has an exclusion for an employee who works as a security officer solely on Saturday or Sunday, and an employee who temporarily replaces a building maintenance worker who's absent for less than 1 week, if you bring in a substitute for a short time. What it requires is a minimum of 30 hours per week. Currently, I wouldn't say all, I'm not sure it's all, but many of these employees are represented by a union. The SEIU 32BJ represents these employees in various office buildings around the county, and they of course testified at the public hearing. They negotiate with a association of building service contractors called the Washington Service Contractors Association. If you don't belong to the association, which is of course voluntary, I'm told that the other contractors generally adopt the collective bargaining agreement, and it's a collective bargaining agreement that covers not just Montgomery County, but district and Virginia and other areas, but it has different provisions based on local laws. The union, I did have a conversation with Thomas Martin from the union, and what he told me was that I believe it's 21% of the employees working in the county that would be affected by this are currently full-time. The other 79% are part-time. As you heard in the public hearing, we heard from 3 employees who presumably would be affected by this bill, who testified that they're currently working involuntary part-time, I guess you could call it. They're working part-time, but they'd rather work full-time. The collective bargaining agreement has a provision that if you work 30 hours or more, you're entitled to employer-paid health insurance for the employee, not for the dependents. And I'm told that they actually use an HMO, Kaiser Permanente. If you want coverage for your dependents, that's on you if you want to add your dependents. Part-time employees who work less than 30 hours are not guaranteed health insurance. They are provided under the collective bargaining agreement with, I believe it's $40 a month put into a health trust that they can use for that. Obviously, that's not enough to pay for health insurance. The one place in the area that has done this is the District of Columbia. They did it in 2016. Their law is very similar to this, with one big exception. Their law has a provision in it that permits an employer to have 20% of their employees working part-time. You heard two sides at the public hearing, the employees who testified and the union that represents them, and there were a couple of other people who testified in support of the bill, essentially pointing out that, which is clearly true, it's impossible to live in Montgomery County well, I guess, on 20 hours a week at the salaries that they're talking about without health insurance. So that's probably a given. That these employees are then required to probably find second jobs and to try and mesh them together, and it probably doesn't mesh very well. And they still may not have health insurance, although the county does provide some sort of medical care through Montgomery Care, so that if they're a county resident, they would be eligible for. In fact, the three people that testified, I think Linda McMillan suggested that maybe we would contact them if nothing happens with this bill, either way, because they testified that they couldn't go to South America to go to a doctor. One of them testified they really could go to Montgomery Cares, because I do believe they were residents. I believe they said that. Anyway, there are, and the other side of the coin is you heard from the Chambers of Commerce in Silver Spring, Gaithersburg, Rockville, Chambers of Commerce that opposing the bill, because essentially this is an intrusion onto private sector labor relations. You're actually telling, bless you, you're actually telling the employers that that you have to do this. You need to change your collective bargaining agreement. And of course, do we do that in other areas? Yeah, we do. We have a minimum wage law. We have a mandatory sick and safe law. But those are different because those are global, covering everybody in the county. And they're not simply directed at one small group of employees where you're taking sides in a collective bargaining agreement. Clearly, the employers could agree to provide full-time hours for anybody who wants it in the collective bargaining agreement, but they haven't done that. The testimony from the chambers and from Bryant Folger, who owns several buildings and was also representing I think the Apartment and Office Buildings Association, AOBA, testified that this would increase his costs by 10 to 15% for building maintenance, and would make it either one of two things happens. Either they eat the cost, they raise the rents, or they raise the rents. In the office building, if they raise the rents, they're likely to increase their vacancy rate, which is currently in the county at 17% for office buildings. So, there's a plus and a minus. The other discussion was also about the employees themselves. This will clearly help some employees, and it'll clearly hurt some employees because the likely result is you're going to use less employees. So you have less workers, and some people are going to find they no longer have a job, Some people are going to find that they have more hours and they now have health insurance, so it will be good for some and not for others. That seems to be fairly logical. We had a short turnaround from the public hearing to here. The public hearing was last Tuesday. I did contact some people I know in the District of Columbia government, and they said they'd get back to me, but of course they're not in a rush. And I haven't heard anything back from them. I don't know if the district has done any analysis of what their law has done. We did hear two things at the public hearing. We heard from, and these were from advocates for the bill, we heard a statement that the increased cost of these services was only 2 cents per square foot per month. I'm not sure if that's accurate, and I'm not even sure how that factors in. That's not what Brian Folger said, but he, of course, hasn't tried it. He said he has no buildings in D.C. And he's speculating and obviously has a position to advocate as well as the advocates. And then there was someone else testified, Kamalika Das, representing the D.C. Fiscal Policy Institute, supporting the bill, argued that the D.C. office market vacancy rate, although she pointed out it increased, the vacancy rate increased from 11.9% in 2016 to 13.3% in 2019, but she attributes that to increased supply and not demand, reduced demand. I have no idea. I know I can see it went up. The district office market is probably not the same as ours. The district is the district, it's the city, it's where people feel, a lot of people feel that that's where they need to be, and they'll pay what they need to be in the city. Rents are generally higher there. Parts of Montgomery County, maybe in Bethesda or something, are closer to that. Most of the county is not. So it's not clear that the effect here would be the same as it is there, but that's the best information we could have, I guess. And we don't have it. We didn't actually get an official position from the county executive. They signed up to testify, and they had a mix-up in communication and didn't come. We haven't gotten a written statement from them, although I did hear that the county executive supports the bill. The county executive was, I think, when the original bill was one of the co-sponsors several years ago. I asked myself, well, boy, this seems unusual. We haven't done this before. And then I remembered, because I wrote the bill. Yeah, well, we have in one way. We did the displaced service workers bill that actually was aimed at these exact same employees and required an employer who gets a new contract for building services to offer temporary employment to the old contractor's employees for up to 90 days so that people, wouldn't abruptly, because these contracts apparently change abruptly, they wouldn't abruptly lose their jobs. But then when I thought about it, that's a little different. It's not really telling the employer what their terms and conditions of employment ought to be with these employees. It simply says, you need to, it's an attempt to prevent people from being laid off. The testimony we heard on that bill was that in that industry, the employer, the new contractor generally doesn't have a whole staff and will hire most of these employees anyway. We didn't get any complaints actually in that bill, which surprised me from, I don't remember a lot of opposition to the bill. And I don't think we've had, I think it's gone, best I can tell. I mean, if Jim Stowe was here, I could tell you, I don't think we've had any complaints from that. Is he? Oh, he is here. Okay. Well, maybe you'd like to have him come up here then. Come on up, Jim. But that is a different type of thing.
I see Mr. Tibbetts is in the audience. Mr. Tibbetts, don't want to put you on the spot, but if you did want to come and formally get the county executive's position this on the record, you're more than welcome to.
Hello, Dale Tibbetts, Special Assistant to the County Executive. The County Executive does support this bill, and we did, I was just checking, I thought we indeed had sent that letter of support. We did have a mix-up with Mr. Stowe for the public hearing, and so I apologize for that. Fully supports the bill.
Mr. Stowe.
A couple things. First and foremost, in terms of the testimony that we would have offered, if it's appropriate to add that now, I would certainly do that right now, and that we will have benefit of that for the record.
Yes, Mr. Stowe, please proceed.
Thank you. President Navarro, Vice President Katz, and distinguished members of council, first I wish to thank you for allowing this opportunity to speak about this very important issue. We're here to speak on behalf of the county executive in support of Council Bill 1219, Human Rights and Civil Liberties, Building Maintenance Worker Minimum Work Week, which requires certain employers to provide a minimum work week of at least 30 hours for each employee working as a janitor, building cleaner, security officer, concierge, door person, handy person, or building superintendent at an office building occupying at least 350,000 square feet in the county. As you may be aware, workers who work less than 20 hours per week are commonly associated with part-time work status. The 20-hour per week pay in many instances is insufficient to meet the needs of most working families, and often workers must have 2 or 3 20-hour per week or part-time jobs to cover living expenses. In many cases, these workers may already be at a disadvantage with skills levels, educational and language challenges that make such jobs as described the only narrow options available. Equally important is that a work week of 20 hours or less does not generally qualify for employee benefits and meaningful health care. The normal standard for such benefits is usually considered between 30 to 40 hours a week. Should this bill pass, it would meet the goals of increasing the amount of pay per week, adding some certainty to income for workers, and would assist employees in moving closer to meeting minimum economic standards for housing, food, childcare, and transportation. Another important factor for consideration of passage of this bill is putting some degree of control or certainty in the hands of the employees regarding scheduling decisions, as these jobs can have fluctuating hours. Often shift changes with little notice negatively impact the welfare of workers' families and can jeopardize their job status with other employers. A similar law was passed in 2016 in the District of Columbia, D.C., Act 21-485, the Building Service Employees Minimum Work Week Act of 2016. The legislation prescribes a minimum work week of 30 hours for a building service employee, in quotes, defined as a covered employee who performs janitorial services, building maintenance services, or other services in or around a covered location or place of business, close quote. The Act provides for certain exceptions, a notice posting requirement, a recognition that covered employees would be taking covered leave, and penalties for employer non-compliance. Employers with commercial office buildings of over 350,000 square feet of office space are covered by the D.C. Act as well. The enforcement of the Act is administered by the Department of Employment Services, Office of Wage Hour. This legislation only applies to the largest buildings in the county, which have significant building maintenance needs that can support persons working more than 20 hours per week. If approved, the Office of Human Rights would address complaints as directed by the provisions of the law. The Office of Human Rights would also provide support for technical questions that might arise from employers and employees. However, this additional responsibility would require additional staff resources to be determined by the Office of Human Rights. We are in support of the passage of this law, and we thank you for the opportunity to share these brief comments and observations. I did do what I believe to be a fairly comprehensive summary of this particular law or kind of law around the country with some of my colleagues in the Office of Human Rights and Human Rights Commissions across the United States, trying to target some areas that I thought would probably be areas that would be progressive enough, to be honest with you, to have this kind of law present. And there's no human rights organization who currently has the enforcement responsibility to do this task in any other agency across the country that I've been able to at least to identify. Checked in with San Francisco, New Jersey was one of the areas that normally is progressive. New Hampshire also was an area that I normally looked into as well. Philadelphia, etc. And those areas just simply did not have the bill as even in their area of responsibility or authority. As mentioned, the Department of Employment Services in D.C. does have the bill, as you all know, and do make the enforcement efforts there. I was not able to have them return my phone calls to kind of get an idea about number of complaints, how in fact they administer the law, what staff requirements were in place, if any, as far as that is concerned. And so that information still is a little bit undetermined at this point. Some of the tasks that obviously would be in place would be necessary to know what their universe looks like at this point in time, to determine the number of buildings that may in fact comply or fall under jurisdiction of this law would be something that needs to be done in terms of that kind of study and survey. A number of employers who have similar kinds of responsibilities for those buildings would also be something to be determined as well. So a lot of work, I would think, needs to be done in order to be able to position then to effectively enforce and administer the law were in fact this law passed. However, for all the reasons stated by the county executive in his letter of testimony, clearly it is something that we need to pursue and to see how we might be able to have this law go forward, because he's in full support.
Thank you very much, Mr. Stowe, and I appreciate you adding those comments for the record, and appreciate Mr. Tibbetts doing the same. This is the first time we're hearing this testimony, obviously, so I, for one, will need a little bit more time to process it and be able to figure out where we go from there in terms of questions. And as I've mentioned to you before, I am a huge fan of your office and your work, but also, as we discussed during the last budget deliberation, very sensitive and concerned over an already stretched staff. And so as we looked at the fiscal impacts of this potential bill, and there's still a lot of questions about what those potential fiscal impacts would be, while we have you here at the dais, and I have a lot of questions about a lot of different areas of this bill, as I'm sure my colleagues do as well, but since we have the benefit of you right here before us, if you could talk about your current status with regards to staffing and workloads within your current staff, and acknowledging that in our last conversation during the budget process, you had expressed understandably some concerns over the current status. If you could talk a little bit about that, and just so that with the implementation of any bill, you want to put it in the best possible position to succeed, and since your office would be the most directly responsible for oversight, if you could elaborate a little bit on your current comments and testimony, that'd be helpful.
Two things I might say, and for the record as well, with the earlier comments that Bob had made with the displaced worker bill that was passed. Another one for which there was nobody else doing that work. Had no idea how many cases may come up. And in fact, we've had about 20 cases that have come up as a result of that law that we're able to process and move through. As the case with our work currently, we obviously don't know what the level of the caseload is going to be from year to year and from month to month as it may be. We currently have 4 investigators. We had 10. Our caseload now runs around between 250 or so to 300 cases a year. Again, fluctuates up or down depending upon, again, those that are actually filed with us. Each investigator will have somewhere between 40 cases, a little bit better than that. And so we try to move through as best we can. This past year, we've been hampered a little bit more by that because we've had one of our members who has been gravely ill, and so it knocks us down then to 3 investigators. But we move on. And I think one of the things we try to do is to estimate in our own minds that we have done, let me back up a second, not estimate, we in fact try to speculate on the number of cases that we're going to get by putting the forecast together based upon the previous year's cases that actually came into our inventory, and try to figure out better ways then to move through the process. We're trying to do more emphasis behind the area of mediation as an example, trying to streamline that process so that if we get many more cases that are actually resolved in the mediation process, obviously fewer cases then go into full investigation. And that, of course, is the total choice of those involved in the complaint, the complainant and the respondent. So that's one of the areas we've at least tried to point out as being an option, try to reduce some of the incoming traffic as far as complaints are concerned. But beyond that, we have an EOC contract we try to work with as well that also brings in cases that don't come to our office directly, but may go to, again, Baltimore as a field office for EEOC for our district. And so those cases also are transferred to our area as well, because the cases may have actually occurred in Montgomery County, but in fact they may have been filed with EEOC as an example. So those cases come in, again, not knowing what they're going to be in advance. They come in. Now we actually, in some instances, certainly want them to come in because we are closest to where the actual complaint occurred. We believe we ought to be the ones actually trying to affect and actually resolve that matter as far as our residents are concerned. So you have pretty much compression points that do occur. You have compression points that feed into the complexity of the cases themselves that sometimes pushes them out. I'm pleased to say, however, we are now down to 15 months or less in terms of actual closure time for our cases. We were at 24 months at one point. We're down to 15. We are making progress. And so it is trying to figure out how we maintain and get involved in areas where we can really make a big difference that makes us, I think, a little bit more effective than we were than the year before. It is obvious that, however, as cases increase, with 3 people and now a 4th one is coming back. But when the caseload increases, we get that compression point I mentioned a minute ago. And we have to kind of work through it and chop through it as best we can, and we move forward. So additional staff would be extremely helpful, period. We have, however, tried to work within the confines that we have found ourselves in to move those cases through as best we can and do the most comprehensive job we possibly can on those cases. That's the other thing, too. You could probably do them quicker, probably do them in a way that you could expedite things, but we want to make real sure we've given every benefit of both the complainant and the respondent to present their best case, and thus determining then some sort of final determination and ultimately resolving that matter.
So I often use this metaphor that we try to make $1 out of 75 cents. In the case of your office, you're literally trying to make $1 out of 30, based on the staffing complement that you had earlier. Mr. Tibbetts, I appreciate the county executive's support of this bill. Is he committed to additional staff within the Office of Human Rights to address some of the ongoing caseloads and then the possibility of additional caseloads with the enactment of this bill? And of course, as we know, we're seeing significant rises that directly are covered within Mr. Stowe's office. Are there plans, or has that been discussed as part of the potential fiscal impact to correspond with the enactment of this bill?
It has not been formally discussed with enactment of this bill. We just came through the budget cycle, and everything was balanced against everything else to have that discussion about increasing here. Where does that come from? I think would be appropriate to discuss with the council and council staff and others as well. So there's nothing formal at this time should this bill pass on the staffing.
Gotcha. Thank you, Mr. Tibbetts. I have a few more questions, but Councilmember Rice has been waiting patiently.
I think on Circle 45 there is a list of all of the buildings, at least from a database processing, that could possibly be affected by this bill. So we have kind of a framework. We don't know how many of them would be actually affected by this bill, but we do have kind of a starting universe.
I appreciate that. Thank you. That's helpful. That's right. I do have questions with regards to those numbers, but we'll get back to that in a second. Councilmember Rice.
Yeah, well, Mr. Chair, as always, you did a great job of asking questions, and I'll just chime in that during the budget process, we were very concerned, Director Stowe, about the workload of your employees. Obviously, while it's not directly related to the passage of this bill, it is a part of implementation. And so from that perspective, we shouldn't be passing something if we're not going to be able to implement nor enforce it. And so from that perspective, I'm really concerned about the workload of your employees. I know that we had discussed that in budget, and for the first time, you have been a person who's been very willing to ensure that you worked your department as much as you could to make things happen with minimal resources. And last year, I heard you in front of us saying, we've reached that limit, we've reached that tipping point, and we really need to have some additional staff, which to me says that we certainly should have listened to that, because I know all of those years before you had said, look, we're going to make it work, we're going to make it work, and you did. And you talked about where that point was, and now with the person who's now out, you're even farther beyond that tipping point. So I would just say, Mr. Tibbetts, to you and to the county executive who sat here, so he knows, he's heard it as well from Director Stowe, they're in a position now where they need that additional help. And so similarly, as we've heard from other things, I would hope that with support for this bill coming from the county executive, that certainly we would tie in additional staffing. But regardless of this bill, the staffing needs to be there, because the simple fact is that people who have felt as though they've been aggrieved in our system are still waiting longer than they should be to have their day of recourse and justice. And so from that perspective, I just really think that we need to pay very close attention to this outside of the context of this bill, but even more so if we're going to layer that responsibility on top of you. And so I just wanted to put that out there. I just want to say one thing, because we kind of touched on it, and so, Mr. Chair, I'm not going to jump into other details, but since we already talked about who this would affect, I would like to ask for, and I know it's going to take a minute, but and by a minute I mean a while, but it's incredibly important, and there's a reason why. I really want to know the total number of people in each of the individual sectors and the breakdown of full-time and part-time. I don't want it to just be a generic number, because I want to know how many security guards we have and how many of those are full-time and part-time, how many folks who are concierge and how many of those are full-time and part-time. It's incredibly important, because as we look at this blanket overarching, are some better than others and in better positions, and so therefore may not need as much, or may have some other sorts of things? Can some of it be explained in terms of, and I won't jump into one of my concerns about a specific sector, but there's one particular sector that, again, I'm very concerned about and want to understand where we are in terms of full-time and part-time. So from that perspective, if we can try and get those numbers, that'll be incredibly helpful for us. It'll also be incredibly helpful for you, Director Stowe, just in terms of understanding who your folks are, who you'll need to work with the most. Who are the folks who are the most in this danger of falling outside of, and then who's the bill going to impact the most? That's good to know also, right? Is it going to affect concierges the most? Is it going to affect janitorial? Is it going to affect security? It's good to know that too, right? So on all of these fronts, I really think that information, the buildings is great, but we really need a little bit more information in terms of those exacts. So that's it.
Thank you, Councilmember Rice. Councilmember Glass.
Thank you for my colleagues for teeing up the conversation and the perspective in which we started this engagement, and for both of you referencing the conversation that we engaged in during the budget process. And Mr. Stowe, your office does tremendous work, and as I said during the budget hearing, I think there's too much placed on your plate and too many different items on that plate as well, because essentially what your office, your small office, is tasked with doing is enforcing workplace and employment law here in Montgomery County, and then dealing with the human rights and civil rights advocacy, making sure that our immigrants receive the information that they need, making sure that the racial equity work, which we are underway with, gets continued, and then making sure celebrations like Pride Month and other events are recognized and warmly welcomed within the community. And I think it's disjointed. It's tremendous work and you're doing very well with it, but I'm not sure that it should all be there. And so I'll say for the record now that as we talk about employment law, which this bill relates to, and as the county executive for a long time has advocated rethinking government and reshaping our bureaucracy to become more effective, I think there should be a conversation about possibly doing some of this work with the Office of Consumer Protection, rethinking maybe the way that department, that office operates. I think there should probably be a more centralized employment clearinghouse agency here. And we have a bunch of functions and missions throughout the government. And what that ultimately would end up doing is having that one agency or office fully charged with all of this monitoring, and then allowing the Office of Human Rights to fully fulfill its mission of making sure that everybody in Montgomery County, all 1.1 million people, live equitable lives, are free to express themselves, and to feel safe in their environments. And so I just want to put that on the table and appreciate the concerns that I share just about your ability, the office's ability to carry out some of this work. So putting that aside, I do have some specific questions about this piece of legislation. It is undeniable that housing, healthcare, and transportation are the leading costs for any individual living in the DC metro region. And so this legislation deals with healthcare. And so as we look forward towards the 2020 elections, and I think now we're up to 25 Democrats running. And there are a few on my short list, right? I'm not going to get into that right now, but all of them on my short list want to expand healthcare. Whether it is Medicare for all, universal healthcare, expanding Obamacare for more universal access, those are the Democrats I'm personally supporting. And I'm curious to know how this piece of legislation, what would happen if healthcare nationally were to be expanded, whether there would be a sunset or whatever the need might be if healthcare nationally or regionally is expanded. Do we have any thoughts about that? Or is that just kind of a question to put out there?
Well, it goes both ways. Right now, the Affordable Care Act has been under attack by our own government that enacted it in the first place. The Justice Department is currently arguing in litigation that it's unconstitutional since the Republican Congress decided to eliminate the individual mandate, that what was left is unconstitutional. I don't know how that's going to come out, but that's where the 30 hours comes from. The Affordable Care Act has the requirement for employers to provide, large employers to provide health insurance for everybody who works 30 hours or more. And that's why since that act, as you've seen some employers go to 29 and less. So, that's a possibility. Obviously, without getting into personal politics, that could hopefully change, in 2020 with a new election and a new administration. And I suppose if that happens, that wouldn't affect this bill. The bill would simply require full-time work. The bill doesn't require health insurance. It requires full-time work. If the Affordable Care Act was held unconstitutional and the employer and the union, I guess through negotiations, lockouts, strikes, or whatever happens, and the various ways things are changed in the private sector, theoretically, these employees could lose their health insurance, but still be working full time. We thought about, well, can't we just mandate they have health insurance? And I don't think we can do that. I think that's already preempted by federal law in ERISA, and I think we've looked at that in the past. So what this bill does is it's an end run around it. In their current collective bargaining agreement, which is up for renegotiation, I'm told, in October, right? So how much they change or whatever, but the current agreement and stuff, benefits that are in the agreement are generally hard to get out for the employer. Presumably they won't be able to change, they won't, well, they may not even look to change that, I don't know. But this bill just deals with full-time employment, doesn't guarantee that people are going to get health insurance if they're working full-time. I mean, they would under the collective bargaining agreement. If the collective bargaining agreement stays the same and the Affordable Care Act is struck down, these people would still have health insurance under the collective bargaining agreement if they work full-time. So in that sense, but you have to, one of the goals of the bill and one of the problems we're trying to correct is people that don't have health insurance working in the county residents without health insurance. Of course, we also don't know how many of these employees are actually county residents. They're working in the county. They don't necessarily need to be county residents to work in the county. But, this would certainly, I'm sure a large group of them do live in the county, and it would require them to be given full-time hours, and under the collective bargaining agreement, then they get health insurance. The Washington Service Contractors Association in the next bargaining agreement could come back and could agree to give everybody health insurance. It's 20 hours a week or more. That could happen. I mean, that's certainly up for, this is a mandatory topic of collective bargaining under federal law, which is one reason why, there's a little paragraph in the packet about, is this going to be preempted by the National Labor Relations Act? I don't think so, because it doesn't change the procedural method of bargaining. It simply has a minimum standard, like the Sick Leave Act, or but that's not absolute. But I don't see this bill getting challenged on that basis. The county attorney's office didn't bring that up. They brought up a potential equal protection clause with large buildings and small buildings, but that's not a suspect class, and I think there's clearly a rational basis for that, for picking a size of building. But, so I don't think there's legal issues with this bill. I think it's really, we're into policy. So if Medicare, gets expanded to all, like some of the Democratic candidates are, and of course, they're not, they wouldn't be able to, the president couldn't do that by themselves anyway.
I'm aware of the
if there's still a
political
Republican
breakdown
Senate,
right on the Hill, but
and Senator McConnell's still there, it's not happening probably either. But
well, so if I could interrupt you, I'm a hopeful optimist, and I understand that none of that is going to change in 2021 on the turn of a dime, but I'm hopeful that we get there, right? And so as it relates to this legislation, just trying to figure out, say in 2022, 2023, healthcare is expanded and all or as many people are receiving it as possible, what the implication is. And it's an open-ended question. And it comes back to, what is the purpose of the legislation? Is it to expand the healthcare? Is it to provide quote unquote full-time work for people? And I think that is the heart of the answer to this question. The other question I have as it relates to the bill, as I read it, extending to 30 hours and extending healthcare only would be provided to the employee. Is that correct? Not to families. That's the question.
under the collective bargaining agreement, and we're not mandating health insurance in this bill at all, we're mandating full-time hours. And under the collective bargaining agreement, the current agreement, the medical care is only for the employer paid. You can add dependents, but that's at your cost. That's the current collective bargaining agreement. Again, up for renegotiation in October. It's a 4-year agreement that's about to come to an end in October. So That's why I'm talking about is what we're talking about are mandatory topics of collective bargaining that can be bargained with the employers. And certainly it's a matter of, in the private sector, to be honest with you, it's a matter of economic force and whether you get that or not. That's the National Labor Relations Act is basically designed to resolve disputes, unlike the county collective bargaining agreements, not through arbitration, but through strikes and lockouts, and who can last longer. And that's the federal law of the land. So what would happen? I don't know. I mean, I'm sure the union would be happy to, or would like to get health insurance for all, right? Whether you work 20 hours or 10 hours or 30 hours, they were not able to get that from the employers. But it could happen. I mean, so that's what we're kind of moving into. It's almost as if instead of negotiating with the employer, I'm sure they negotiated with the employer. I suspect they asked for this, but didn't get it, and so now they're coming to the county to try and get it mandated, and it's a policy question as to whether it's a good idea or not.
Yeah, last thing I'll say on this is I think it's fair to say with the highest degree of certainty that everybody at that negotiating table is watching this right now, and they are monitoring this conversation, and the fact that we're having this conversation shows how important it is. And so whether it's done here, whether it's done there, it's an important issue. We all want our residents and county employees to be safe, to have health care, to have their families be the healthiest they can be. It's a matter of figuring out how we do that. And so there are multiple conversations taking place at the negotiating table, at this dais, within this building and across the street. And so I appreciate the questions that have been asked and the information. Hopefully we can get some of this information as quickly as possible, but I understand how all of this works, and so thank you all.
Thank you, Councilmember Glass. Very good points. Definitely associate myself with all those comments. Again, since Jim, you're here, I want to ask you specific questions with regards to oversight and how that would work, and then I will fall back to ask more generic questions generally and kind of go from there. So you had mentioned in your testimony, Mr. Stowe, that you had looked at other jurisdictions to see who had enacted similar legislation, and I believe, and I just want to confirm I heard you correctly, that you didn't find any other jurisdictions that would have direct oversight responsibility afforded to the county. Is that correct?
That's correct. The closest that I came to was San Francisco, who had one that really dealt with the restaurant industry, dealing with more guaranteed hours for waiters and waitresses and that kind of thing. But nothing that was as detailed, as specific as this was, except for the DC version as we've talked about.
Right. And I appreciate that. That's helpful context. And did you have the opportunity to speak to whomever the regulatory body is in DC about their experiences? And who is that body?
Department of Employment Services.
Okay. I do think as a follow-up it'd be helpful just to make sure that if we move forward, you're put in the best position to succeed. If I'd encourage you to have that conversation with that sister agency to just find out from their experience what this has looked like and how it has worked for them. If we could get a report back on that, that'd be very helpful. And finally, if you could just, well, not finally, for now, could you walk me through, so how would the enactment of oversight look like? A complaint is made, we enact the legislation, one of the 93 buildings that are part of this legislation currently are impacted. The complaint is presented to your office. Walk me through what that process would look like within your office of investigation and how that would work.
Let me speak to just the investigatory part. As I mentioned, since nobody else is doing this, we don't really have a model to give you benefit of what that would be from step one in identifying the property and so forth and so on. But what would happen then is that we would do an intake. That would be the complaint coming in from a person who might feel aggrieved Once we got that complaint, we would then try to notice then the respondent, in this case the employer, of the complaint and its existence and give them a chance to respond. They would in fact respond, and then based upon that response, we begin the process of the formal investigation, actually taking testimony, maybe in this case we want to do on-sites to ensure then that we have the basic parameters followed, the 350,000 square foot as an example, and then begin to pull the information together, all the facts together that may again set up the case and lead us to a determination whether or not it happened or not. It seems to me then pretty clearly that if there is a policy for which persons then have not been able to get the afforded hours, things looking at, again, time cards, looking at sign-in sheets, et cetera, might get us to that point fairly quickly, as opposed to the work we do where we're looking for, again, whether or not the preponderance of the evidence is on then the complainant side or on the respondent side. Pretty clear. If you work 30 hours, there'll be some evidence that that took place. If 30 hours were available for you to work, there'll be some pretty, again, evidence that would be available to us as well for that situation. So I think then that, and I'm thinking this through again, since it doesn't exist, that we'll probably have to work in that particular regard. Once we in fact were able then to substantiate whatever the evidence led us to, we in fact would do a determination like we do anything else in our case, right? And that would be then to notify persons involved, both the complainant and the respondent, about what our finding of fact is and whether or not we believe then, based upon the law, whether 1219 in fact has been, again, violated to the extent that we've been able to prove it. And here then are the steps that are next able to be taking place. In instances where we're not talking about this particular law, we would lead then to conciliation. Particularly, we had a situation where we had a probable cause finding. In other words, we had reason to believe that what's been alleged did in fact happen. In those instances, parties have one more time to kind of work it out, to get the matter settled, and get to a point beyond the actual complaint itself. If that does not occur, then we lead then to the process of a formal hearing that is right now it's been done by our administrative zoning board right now. And that finding is then given to our commissioners. Commissioners form panels of 3 persons who hear these various cases, and then their ultimate decision is final. So that's the way it would work. So I think that the part that is probably a little different, as I mentioned a minute ago, is that the verification process, I suspect, will be a lot cleaner, a lot more specific than it is in regular kinds of employment discrimination cases. And that may be something that may move a little quicker than would be other kinds of cases, I suspect.
That's very helpful. And then, so you obviously have, as we went back, you have 3 full-time now. You'll soon hopefully get a 4th back, but if they're coming back from illness, they may not be 100%. How does the workload, do you have subject matter experts, or are there just general, as the cases come in, they're assigned with whoever has more capacity at that moment, or within those soon to be 4, are there subject matter experts within those 4?
We have, first of all, subject matter experts. All of our folks are highly trained, been in the business for 15 years or more, and so they're skilled both in housing discrimination as well as in employment discrimination, public accommodation discrimination, and all the things we had added to us. They are fully able and capable of doing that kind of work, and would be here if we had more folks doing it. So I don't think the issue here is any different at the end of the day, process-wise, than any other subject. Now, the specifics of this, learning a little bit about what this means in terms of the industry and this kind of thing, this is the part of the thing that happens in the process of doing the actual cases themselves. We learn about the fact that what a concierge does or what a building security person does as an example, and whether or not what we're being told in terms of whether the work was just not available, the work was not whatever, we have some sense about whether or not that is realistic or not. And so those are the kind of things you actually learn as you do and do the cases themselves. As I mentioned, and that there's nobody else in the country currently, anyway, on a human rights kind of a configuration who is doing this work. We don't have benefit of their lessons learned. And as you mentioned, maybe we'll find out from Employment Services what their particular findings have been to give us some guidance on that. But we have very capable people, and the job itself is not the issue in terms of the complexity of it. We can get it.
Right.
We just need more folks to do it.
And the disproportionately a number of the county residents who would be impacted by this, as evidenced especially by the testimony given, may speak English as a second language. I know you've got Loretta, who is a rock star and obviously is totally fluent in Spanish, but can you talk a little bit about the ability of your staff to address where there may be English as a second language component to this, and if not, how you address that with interpretation? I know your office does it as best it can, but if you could elaborate on that. And I'm putting a pin in this as we discuss your office generally moving forward, in addition as it relates specifically to this bill, but I also want this within the context of a larger conversation.
We have actually 2 Spanish speakers. One of our investigators also speaks fluent
Great.
Spanish from Puerto Rico. So as far as that's concerned, we've got that pretty much covered, we believe, in terms of trying to address those particular residents. Beyond that, we have a contract, as you may know, with the language line. The county does, and so we always have access to speakers from any country across the world, and able to have him or her then vis-a-vis through either telephone and sometimes actually in person, to be that third party to help with the communication process. So that has never been an issue for us in terms of any sort of barrier. The one thing I would say, and this goes back to comment that Councilwoman Glass made earlier, what all of the enforcement agencies have gone to is the same configuration that our office has. You've got both outreach and you've got complaint in the same area. EEOC now spends an inordinate amount of their monies now on outreach. As a matter of fact, they give us $1,000 every year to do outreach. Because what they found out is that you can't be on the complaint sort of merry-go-round, because you never get to resolving anything, because it just keeps fumbling around, back and forth. What they've learned is, and we always knew this, I've been in this business now 30 years. What I've learned is that you have to have your hands into the ability to go into the community, so that when you have to address issues vis-a-vis through a complaint, there's a level of understanding about what happens and why these things occur the way they do. And when you do that, while we try not to have any particular partisan view one way or the other between the respondent and complainant, we have to have an understanding about the community that we serve. And you cannot do that sitting behind a desk doing complaints. Can't happen. Never has happened, never has worked to any significant degree. And evidence of it now is the fact that, as I said before, both HUD, Fair Housing, and also EEOC, with employment cases, have outreach as a key area. Matter of fact, they pay, in the situation with HUD, thousands of dollars to agencies to create outreach opportunities. Because you've got to have that back and give and take. So anyway, having said that, then, one of the key components I suspect then, trying to kind of pull all that together would be trying to figure out how we now learn this new world, if in fact the bill goes forward and is passed. How do we learn about buildings? How do we learn about the kinds of professions that go on and affect the upkeep of that particular building and premise? And so the idea that we do this bit by bit allows us then to build a kind of relationship with folks that allow us then to do a better job of understanding all of that. Right. So I would just put that out there as kind of a backdrop to how we do the work.
Councilmember Glass.
I'm going to pick up on this dialogue, which I sincerely appreciate, and I know it's not pertinent or relevant exactly to the legislation, but as we try to figure out the enforcement mechanisms, that's why this is an important conversation. Yeah. And I appreciate your thoughts on the nature of the work that you do and the need to be external and then the internal component. But what I'll say is that within the county government, your office has that dual function, external, internal. Let's synthesize it to those terms. And then we have, again, consumer protection, which is internal. And then we have community partnerships, which is external. I think there's a conversation to be had about figuring out how 3 different offices, which at the heart of it have very similar missions to serve the people of the county, to serve the specific needs of the county, and be responsive to the problems that arise from all those different demographic groups. And so, in my mind, at this very preliminary stage, that is the conversation that should be had, mixing that external and internal work, and we have different departments and offices doing a mix of that. So, to be continued for sure.
Thank you. Councilmember Rice. Oh, you're good. Oh, okay. I just had One final question, Mr. Stowe, and then we'll go back to sort of the more general questions with regards to the bill. So you had mentioned that there was a caseload of a couple dozen with sort of the sister bill that Mr. Drummond mentioned is the most similar to the one we're enacting here. And you described a little bit about sort of the length of time it takes to address those specific cases. So you're somewhat familiar in this space with regards to commercial office buildings, but could you just talk briefly about your experiences with those 20 cases? Were there layers of complexity that would that we should consider as we enact this particular legislation to make sure, again, if it moves forward, that it's done smoothly? Any lessons learned from those 20 or so cases that may be helpful as we deliberate over this bill?
Yes, I think in the instance that had at least 14 or 15 of those cases came from one employer, one circumstance, one situation. Issue was language. That was also an issue of trust. And this is where, again, you've got to have the external piece to be able to then establish that you're okay. You can come to us. You're going to be a situation where not only will your confidentiality be protected, but also there are other issues, because we don't, in fact, as you know, require that we see any sort of identification vis-a-vis any kind of citizenship requirements. So as a result of that, then we had to work through that first to make real sure, even with our Spanish speakers, that was a bit of a challenge, because what they saw was we're out of work. We're out of work, and so as it turns out, then we went piece by piece and had to do this, I guess, at least, I'm remembering anyway, at least a couple of times to kind of bring the process full forward. Actually brought them into our offices, had a conversation with them about what the law says, what their rights were, and how, in fact, to affect those rights in their particular complaint. Once we kind of worked through all of that, the process was then believing that whatever it is we said we were going to do, it was going to actually take place. That was the other thing that happened. And at the end of the day, we ended up having to resolve and settle that matter and was able to move beyond that. So what we learned was...
Right, that is a fire drill, so we will adjourn until we all go down to the appropriate... Downstairs or across the street?